car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Hello, welcome to another edition of The Attorneys. You can consider this show your comprehensive guide to estate planning or probate. I'm Art Franklin along with Michael Eldridge, and we've got a special guest with us, Joi Travis. Thanks so much for being with us, Joi.
Thank you for having me.
Yeah, this is Art. This is always one of our most popular episodes, and I think it's probably going to be more popular. We have a first-time guest, but it's not her first time talking probate, trust me, and the ins and outs of probate. But this is something that I have found when we get calls on this, and we get a lot of calls on it, that it touches everybody's life, across the country, regardless of who you are, where you're from, what you do for a living. The issues in probate are going to come up at some point in time, and you need answers, and that's why we love having someone like Joi on to talk us through those issues. And every time I do this episode, I learn so much. But thanks for being on, and tell us a little bit about what you do day to day in your practice before we jump into it.
Of course. So I have my own law firm. It's called Travis Law, and Travis Law focuses on family matters, and we do family law matters as well as probate matters. I've also been doing some criminal work as well. But probate is something that when I became an attorney, it was something I just saw some deficiencies there with people not really understanding how probate worked or what probate court was really about. And so that's where I found my passion, just really trying to empower and engage people about what the probate court is and how to use it.
Right, I'm sure with the way probate works in terms of the issues, then we'll get into the issues, that you end up developing relationships with these people because you're going into in some of their most trying times, but in some of their most important times of their lives after they lose a loved one, for example, that I can see how it would naturally kind of fall into you also doing some criminal work, also doing some family matters, because when you get and have relationships with those people, other things come up, God forbid, and so it sounds like you're a good lawyer to go talk to about probate for developing those relationships. So let's just start there. The word probate, walk me through it. What is probate? So
probate, it can mean a lot, but the probate court itself, it actually handles name changes, adoptions, commitment hearings, conservatorships, guardianships, and estates. And, people from all walks of life are going to deal with the probate court. Probate court is also where you get a marriage license, or where you'll also go in to file your land filing, so when you buy a home. So pretty much everybody's going to have some type of interaction with probate court. The most popular thing that people need probate court for, though, is for estates or for transferring assets over when someone passes away. So that's the most widely used purpose of probate court. And I think there's just some misconceptions sometimes about how to use that, or if you have to open an estate for everything that needs to be transferred, because there are some things that you might not need to open an estate for.
Art, that's one of the interesting things that until I actually became a lawyer, I didn't realize is that when I went to the courthouse, it was like you go to the courthouse to get this done because you get it done at the courthouse. And I think we sometimes think of it's just court. And within that courthouse, right, I spend almost all my time in what's called circuit civil court. And you've got family court, and you've got criminal court, and you've got probate court. And there are courts within the court system, and they handle all these different things. And I'll be honest with you, I didn't realize it was that many things. You're the first person to ever come on here and explain so many things. But specifically, that what you touched on is estates.
Correct.
And that's where I think for sure it's going to touch the most of it. Not everybody's going to have to deal with adoption, for example. The driver's license process, we may all deal with it, but that's kind of a quicker process. Walk me through in terms of the day-to-day, in terms of what you see in estates, and you mentioned that there are some deficiencies. Can you give me some examples in terms of that?
Yeah, of course. So, of course, when someone passes away and they have a will, that means that they've died testate. When you don't have a will, it's intestate. And so when someone has a will, after they die, there's a time period that you must wait and let pass, and then you're able to file their will in probate court. It's basically called probating their estate. And you're opening up their estate basically to transfer assets legally, to alert creditors if there's any debts that need to be paid, but basically put the world on notice that this person has passed away and now it's time to distribute or do something with their assets. And then that also gives notice to those heirs, family members, those that might have an interest in some of those assets as well.
So would you say that the primary purpose for probate is to execute the intentions of the deceased person?
Correct.
Okay.
And sometimes it happens where the deceased person or the decedent does not have a will. And so then that makes it a little trickier for the court to understand what needs to happen, especially if it might be a larger family. There might be more heirs, there might be more siblings, so there might have to be other evidence or other things that are brought into court or to be shown to try to figure out what the decedent expected to happen with their assets.
When you say that sometimes people die without a will, and that's you mentioned that if you probate a will, that's dying testate.
Right.
The flip side of that would be dying without a will, you would die intestate.
Correct.
Well, if there's nothing to probate, how does that work? How can there be an estate if there's no will? What does that process look like?
And that happens a lot too. If someone doesn't have any assets or have anything to probate, then typically there's no need to open up the estate. Sometimes people might not own a home. Right? They might not own a car that needs to be transferred over, or there might not be any assets like a bank account. There might only be life insurance. And with the life insurance, the beneficiary tells the insurance company exactly who that money is to go to. Right. In that instance, there might not need to be an opportunity to open up an estate because there's really nothing to probate, nothing to transfer, and the decedent has already said to their insurance company, this is who should receive my funds for life insurance.
All right, well then let me ask you this. If you do have assets, if you do, and you've got debts too, you've got cars, you own homes. Is it your advice that everyone in those situations have a will?
Absolutely.
Okay.
Absolutely. I think that a will is the best way to protect your assets after death, because sometimes death can bring out the best and the worst in people, unfortunately. Right. And so it's really hard and it's really a challenge. People are grieving. So for them to have to already funeralize someone and then try to figure out what to do with their assets, that can make it a little challenging to go through. And it's very stressful if you don't exactly know what to do. Most times people's first encounter with probate is when someone passes away. And at the probate court, they cannot give legal advice. And so it's always people coming to the court asking questions, but the staff is just there to facilitate and take documents, file them in. They're not there to give legal advice, so that puts a strain sometime on what a person thinks they can do, or even if they don't know what to do.
So as you're initiating that process, what's the starting point? How do you begin that process? Where does it go?
So if someone has a will and they want to probate their estate, there's basically a petition that just needs to be filed with probate. With that petition, you're going to have to file in the will, which is the original copy. Probate court always needs the original copies of everything. So with that will, you're going to need the death certificate as well and the petition. You can file those things in, and then the court will automatically give you the authority to be able to handle the affairs of that estate. Typically, the person that's going to file that will in is the executor or the executrix if it's a female, but whoever has been deemed in the will to handle the affairs of that decedent. And once you file those items into court, they will automatically give you letters or administration so that you can be able to handle any other affairs of the assets of that decedent.
Now, in terms of the process, though, how long does that all take in terms of starting probating the will to the very end?
That's a great question, and it's different for everyone. I can tell you that the estate has to stay open at least 6 months, okay? Once you probate that will or open up the estate, there will be a notice that will be put into usually the Alabama Messenger, basically letting people know that this estate has been opened. It's also incumbent of the person that probates the will, whether it's the attorney or the executor, to give notice to any known creditors. Right. Sometimes when someone passes away, I tell people, look in the mail, check the mail box, because that's the best way that you're going to get information about any bills that may be due or anything that the decedent had going on before their death. But notice has to be given, and so that's what you're going to open up the estate for, but also send an official notice to the creditors letting them know this estate has been opened, this is the case number. If you would like to file a claim, you need to do that in probate court with this case number.
That's Joi Travis. As you can see, that you've come to the right place to get the information about probate. Thank you for joining us here on The Attorneys. We also want to let you know if you want to make a call and talk to one of the attorneys at Hollis, Wright, you can do that as well. That number is 1-844 Law Talk or 1-844-529-8255. Someone's going to answer that call. It's free and it's confidential. You can make that call right now. We still have much more to go through on probate. Stay with us. The attorneys will be right back after this.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best: help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys. At Hollis Wright, we pride ourselves on having a bedside manner that's second to none. That means we listen more than we speak, and we return calls to current and potential clients. Our attorneys are standing by right now. At Hollis Wright, your result matters.
Welcome back to The Attorneys, and we are talking about probate, what it is, and helping you understand it by bringing on our expert today, and that's Joi Travis. And Joi, as we were talking about this, and even in the time when we were away for a commercial break, really talking about the executor. Who gets to be the executor? How is that chosen?
Well, if the person has a will, they will name that executor in their will. And typically when drafting a will, I'm always asking people to have one person as the executor and then a backup, like a successor executor, because you never know if that person may be able to serve. You know, there are instances when the decedent and the executor might be together and pass away, and so then you need someone to fill in. So you always gonna have someone identified. If the person doesn't have a will, typically it's gonna be someone to administer the estate and file the petition, open up that estate, that whoever opened the estate will serve as that. And of course, there might be issues, right? Another family member might not agree with that, so they can definitely challenge that person that is trying to open the estate and administer that estate. So that's always an option. You know, if there are multiple family members and they have a challenge, there's some disagreement, it's always encouraged too for those people to have their own attorneys. So you might want to have an attorney for the executor. They might have their own attorney actually opening up the estate, but people that could be in the will, and if there's no will, people that are family, it's encouraged that they get an attorney as well if they feel like they have an interest in some of the assets or there's some type of challenge or disagreement, because it's probably going to make that process a lot more smoother to work with someone that knows the laws and what actually needs to be done. The laws of intestacy basically tell us if there's no will, who needs to take those assets and how they can be distributed.
Yeah, it's interesting. It's like you were reading my mind in terms of the answer that you wanted, because you started talking about challenging wills, and I don't know if it's the litigator in me or sitting next to Art and hearing his beautiful voice and then remembering that he's from from Michigan, and that made me think about Aretha Franklin's beautiful voice and the fact that she was from Michigan. But obviously that was a huge story in the news, and she had a massive estate, right? A massive estate, and there were challenges. You know, a will was petitioned to the court, and there was challenges from the children about whether or not, number one, it even qualified as a will, or if it was a valid will, if it was a fraudulent will. How does that work? It's like you go to the courthouse, you say, here's the will, let's start the estate, so other people can come in and say, no. This will is not valid. What does that look like?
So basically, a valid will is going to be a will that's witnessed by two people and notarized and signed by the decedent. You know, typically the decedent is also going to have signed every sheet of that will. So if it happens sometimes, you know, there are people out here that don't have the best integrity, and so they might come up with a will. They might draft a will just to submit something that is in their best interest. Or sometimes people have an older version of a will, and the person before they died, they may have made a new will and might not have told everyone about it. So you have to give the opportunity for those challenges, and that's when the probate judge comes in. There's going to be a hearing set because they're going to have to determine the validity of the will, or which one is going to be the valid will. When someone makes a new will, there's a clause that basically says that any will made before this is no longer valid. And so the dates of the will, it's going to be really important to make sure that you have the will with the most recent date. Another challenge I've seen a lot is sometimes when people are sick or they don't have the capacity to make a will, there might be a family member or a friend that helps them draft the will up. And it might not be representative of what that person may have wanted when they were of sound mind. And so that's another clause in the will, that this person is of sound mind. If people want to challenge a will that's been probated, and that person obviously was not of sound mind, and there's facts, whether it's a doctor's letter or a diagnosis of dementia, that might challenge the will because it might not have been made of sound mind. So there are a lot of ways that a will can be challenged, and again, those persons should get their own attorney so that they can challenge whatever's been filed.
Yeah, and I want to talk about that sound mind part because my mom's 97, you know, God willing, she'll be 98 in January in a few months, and when she was making a new will, the lawyer had to come in and said, I need to meet with her separately.
Correct.
To make sure that, you know, this is what she wants to do. And what are they looking for in a situation like that?
Basically, you're just looking to make sure that the person has the capacity to tell you what they want. Right? And capacity is really important because an incapacitated person is not able to really say, this is what I want, because there might have been some influence there. So they're looking to make sure the person might know what year it is, right? And that they're having lucid thoughts or lucid conversations so that they can talk about what's going on in the news right now. Sometimes people with dementia or other problems that affect their memory, they might be able to talk to you in the current, but they might relapse back into the past. And so that's a clear indicator that they might not have the capacity to make a current valid will, or that they're of sound mind. So you're just looking for factors and indicators that show that this person knows who they are, they know exactly what they're doing, they know what today is, and they know why they want to do it, and they actually want to do it, and that there's free from undue influence or coercion.
Fortunately, she's better than I am. I leave the room and I'm like, what did I walk in this room for? And she's all good in that respect.
Yes.
You were talking about a minute ago that when people create a will, I guess typically or almost always, they put in there who they want their executor to be?
Correct.
All right. This is my question.
Okay.
What if I don't want to be the executor, but you put me in your will to be the executor? Do I have to be the executor?
You do not have to be the executor. And that's why, again...
I will be. I was just...
You know, when I make a will for someone, I always have a conversation with them before we draft that will. Please have a conversation with who you want to be the executor, because a lot of people aren't comfortable with doing those types of things. But that's also why we ask for a successor. Right? So that person, if that person's not able to serve, and it says that in the will, if this executor can't serve, then this next person should be able to serve as the executor. So hopefully a person that knows what they're doing, making a proper will, knows some of those safeguards and things to put in place so that, like I said, if the executor is not willing to serve or cannot serve, there's someone else that's going to come behind that. Kind of the same thing with a power of attorney, right? A power of attorney is for in life. The will is for death. So the power of attorney, you're going to have someone that is your POA, your power of attorney, and then you always want a successor power of attorney. So if that person can't serve, the next person can.
So here's my question. Michael and I are brothers.
Okay.
he's been named the executor. I want to know, is he going to be compensated because he's the executor?
That's a good question. It depends on a lot of different things. If the estate doesn't have any money and there's only maybe an asset, maybe a house, and you're just trying to change the name over for the house, there's nothing to be compensated. I have seen estates where there's been a huge pot of money, and you might have to work to get that money, whatever it may be, or you might have to work to sell the house. Sometimes if you're going to do something like that, it also depends on what the will says as far as compensation for the executor or what to do with funds that come from the estate. So hopefully the will should tell us that, but there is a statutory, fee, for lack of better words, that can be in place for an executor or someone that's administering the estate.
Yeah, it's like an administration fee.
Correct.
Similar to what you see in bankruptcy with the trustee.
Correct, yes.
That's how those conversations can get real hot.
They can. Sometimes they can get real ugly because, if your brothers, it's like, why would mom pick you to be the executor and not me?
And why can't I get the whatever compensation instead of Michael, my brother?
Correct.
All right, we're on to something now. We're going to continue. We're going to, in fact, wrap up this conversation after this break, but want to remind you that we have a QR code that's on your screen right now. Take out your phone, scan that QR code, and it'll take you to Hollis Wright. You can ask a question there. You can also click on our social media platforms, get the information you need from Hollis Wright. Stay with us. The attorneys will be right back.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
Did you know when you hire Hollis Wright, you are still in charge of your case? Our attorneys at Hollis Wright are client-centered, allowing you to help us control your case and result. At Hollis Wright, your result matters.
I want to welcome you back to The Attorneys, and we're talking about probate right now as we come back with Joi Travis, of course, Michael Eldridge here as well. And we were talking about the executor before, Michael and I, brothers, and we were going back and forth, and you explained that. Explain this for me. What if I have a probate attorney who's working on our case, and I just don't like the way this direction is going, and I don't like this probate attorney? Can I get another one? What can I do?
So if Michael was the one that's the executor and opened the estate, he would have more than likely found the attorney or hired the attorney, and the attorney pretty much is working on his behalf, right? Mm-hmm. You're kind of going into it that we're going to open the estate, we're going to do this, but then something comes up and I think that I need my interests preserved. That's when I would encourage you to get your own attorney.
So we've got two attorneys working on it.
Yes. So sometimes estates can be a little kinky because if there's a lot of different siblings or heirs and everyone has their own attorney, everyone feels like their rights need to be protected.
It becomes a crowded courtroom.
Yes.
But ultimately, I mean, that's the goal, right? Is that if there's something, if you have a right and it needs to be protected, then you need an advocate.
Absolutely.
And so that's true of all the heirs involved in a circumstance. Let me ask you this. If I'm sitting at home tonight and I'm thinking to myself, while I am alive, I hear a lot of, you're giving me a lot of knowledge, a lot of information, but I may be thinking to myself, you're also describing some nightmare potential scenarios, and I don't have a will. I don't even have anybody, named as an executor. I don't have any plans. I may not even know exactly what all my assets are.
Correct.
What is the process look like? Because I know for a lot of people, it's scary to even think about these things.
Yes.
But in terms of going and talking to an attorney, what does that process look like, and what would you encourage people to do in terms of how they think about it going in?
So the first thing I would encourage people to do is just start with the list of your assets, right? What do they look like? Cars, homes, properties, anything that's of value, life insurance, anything that when you pass away, something's going to have to be done with because it's of value. So that's the first thing I would do, would encourage someone to just start a list. Then you can get a recommendation for a probate attorney from me or from calling a different lawyer that you may know in a different field, but you want someone that actually deals with probate because it's a pretty specialized field. And you don't want maybe, a bankruptcy attorney.
You can say personal injury attorney. I hired a probate attorney to do my will.
Well, with personal injury attorneys, sometimes they deal with probate, right? Because when people are hurt, if they pass away, you're going to have to open up that estate to continue on with that litigation or whatever's going on. So most personal injury attorneys, they either know a probate attorney or they have someone in their firm that does some type of probate work because it just kind of comes along with the territory. But after making that list of assets, maybe identifying an attorney, call an attorney and set up a consultation with them. Most of the times it could be free, it could be a fee for it, but once you set up that consultation, you want to have your questions ready so that you can ask them, is this an asset that I need to include in my will? Who should be included in my will? How do I make those decisions? Because everyone has a special circumstance. And basically sitting down with an attorney and letting them know what you have going on, they can kind of craft out a plan for you. We want to make sure we have a will, but we also want to make sure that if there's an in-between time before you pass away, you might not be able to handle your own affairs. So you also want to make sure you have a power of attorney or something that helps you, that someone can represent you if you're not able to make those decisions for yourself before we get to the will. The power of attorney is good for while you're alive, but the will kicks in after you pass away. So you want to have all those safeguards in place. Also, I encourage people to have a POD on their bank account, a payable upon death. Every bank account will allow you to have this. This will let you name someone that can come into the bank with their death certificate and basically access your funds, whether that's closing your account, taking the money out, but this makes it a little easier so that this part of it doesn't have to pass through probate as well.
It's interesting she says that about personal injury attorneys being familiar with probate. It's true. If we have a wrongful death case, you're going to have to open up an estate. If there's somebody in bankruptcy, now you get, as a personal injury attorney, thrust into bankruptcy. Criminal court, if you have overlapping. And you know what I have? I have not figured out all those areas of the law. I have people like Joi on speed dial to call and say, hey, I need help because we've got a probate issue. I want to make sure everybody's doing this the right way. In terms of the process of getting a will made, you talked about getting a list of assets. Once they come to you, how long does that process typically take?
Not very long. Typically, when someone comes to me, I've already had them to make this list. Sometimes I might even bring the deeds to the property because the other part of that is that once we make the will, I want them to be fully prepared. So I'm going to give them a folder so that we can create that will, have everything in it. Drafting usually doesn't take long. It's based off how many assets. It can be between a week and 2 weeks, but it doesn't really take that long to draft it and then make sure we have people in the office that can witness it and get it notarized. But I'm also going to encourage them to make sure they have a copy of their driver's license with the will, a copy of their birth certificate, and any other important documents. I give a folder so they can put everything in one place so they can make sure they have it. And of course, I scan a copy in just in case the family might not be able to find it, because if you probate a will that's not an original copy, you can still do that. You just have to get a bond for that executor. Now, bonds are sometimes not easy for everyone.
Right.
And so that is a challenge sometimes. That's why it's really important to have the copy.
Legal representation.
Yes.
Joy, you just made a very complicated matter a lot more understanding. Thank you so much.
Thank you. I appreciate it.
That's Joi Travis, of course, Michael Eldridge. Thank you for watching us here on The Attorneys, and make sure you make an appointment to see us again next week. So long.
Thanks for watching The Attorneys, sponsored by Hollis Wright.